If you spend half your time looking at your laptops, I don't know what movie is showing on your laptops, and I've gone to the Twitter handle, so I know you are not tweeting, right? I would like to encourage you that to keep the speakers encouraged in this session, that as important as the business on your laptop is, would I like to encourage you that when you look at them, you share an energy with the speakers. Please, let's all just be part of the meeting. Let's not look cast down. We know that IFFs are a big thing, but let's all be engaged and participate. Thank you so much, because you've understood the 2 points: multidisciplinary knowledge and narratives, and number 2, your laptops are important, but what's most important is we came here to engage. Thank you.
That is extremely difficult to follow, Brian. So I will start by saying, well, that I learned a lesson and I wasn't using my laptop this morning because I listened to what you were saying, and you will have noticed that I have yet to tell you my name because I've learned the lesson of Brian's leadership coaching. We're here today to talk about a certain set of disciplines and professions, specifically what we're going to call gatekeepers, that are important in the phenomenon of illicit financial flows, the money that is streaming out of developing countries. So I'll reference another thing to prove that I was listening to you all this morning. And that was the adage that our keynote speaker, Charles, mentioned about when you put hyenas in charge, don't be surprised that you've lost so many goats. So, of course, our panelists are not hyenas, but I think they will be talking about them. So let me tell you exactly what the title of this event is, or this final session today: the role of gatekeepers in enabling and facilitating corruption and corrupt practices that generate IFFs, the illicit financial flows, from Africa. So we're going to try and look at the steps needed to rein in the professional advisory services that undermine the laws and institutions in Africa in the fight against these flows. So I'll just add, why am I implicated? Well, you didn't mention, Brian, economists, which is my burden to bear. And I will remind you all of the famous joke about the economist that lost his keys when a passerby asks him, why are you looking, where did you last lose them? And he said, over there. And he said, why are you looking in a different place? He said, well, this is where the light is. So in that vein, I'm going to introduce each of our experts on these problematic industries and professions in turn. And we're going to start with Maimuna, who has a PowerPoint, I believe. So I'll ask you to address the lectern. Maimuna will be speaking in French, so if you need the services of the translators, please do put on your headphones now. Maimuna is Diakité is Tax Justice Network's Francophone African Hub researcher. She's based in Dakar, Senegal, and works on their Financial Secrecy Index and Corporate Tax Haven Index projects. She's currently a PhD candidate in economics at CERDI, the University of Clermont-Auvergne. I'll hand over to you.
Bonsoir à toutes et à tous. Donc, le panel d'aujourd'hui va porter sur le rôle des acteurs qui contribuent au développement des flux financiers illicites de l'évasion fiscale en Afrique. Ma présentation se fera comme suit. Donc, je vais commencer par vous parler du programme crucial des flux financiers illicites de l'évasion fiscale en Afrique de façon brève. Ensuite, je parlerai de l'industrie de l'optimisation fiscale, notamment les différents acteurs qui contribuent à l'évasion fiscale, voire à l'évitement fiscal. Par la suite, je parlerai également du rôle des décideurs politiques. Je proposerai, ou du moins je vous ferai part de quelques propositions de solutions permettant d'éviter, voire de réduire le développement des flux financiers illicites et d'autres activités illicites en Afrique. Je finirai par vous présenter l'indice de secret financier qui est élaboré par notre institution, qui permet de voir dans quelle mesure la législation d'un pays l'expose au problème des flux financiers illicites. Les pays africains, à l'instar des autres pays en développement, ont un besoin crucial de financement, notamment financement en termes d'éducation, de santé, voire en termes d'infrastructures routières. Cependant, il est étonnant qu'en même temps, ces pays connaissent de vastes flux qui quittent le continent pour aller vers les paradis fiscaux. Les questions qu'on se pose alors, c'est quels sont les acteurs, voire les actes qui conduisent au développement du problème des flux financiers illicites, voire du blanchiment d'argent et de l'évasion fiscale. Également, y a-t-il des solutions pour pouvoir parer à ces problèmes? C'est à ces questions que je tenterai de répondre au cours de ma présentation. S'agissant de l'industrie de l'optimisation fiscale, voire de l'évitement fiscal, il s'agit des acteurs qui contribuent à diminuer la charge fiscale des entreprises dans certains pays en élaborant des stratégies qui sont sophistiquées. Donc, il y a plusieurs acteurs de cette industrie et parmi les acteurs les plus importants, on a notamment les comptables et les auditeurs. Il y a également les cabinets de conseil juridique, les banques, les centres financiers. On ne peut parler des cabinets comptables d'audit sans parler des Big Four. Alors, qui sont les Big Four? Il s'agit bien sûr des 4 cabinets les plus importants qui fournissent des services d'audit à au moins 99% des grandes entreprises qui ont un chiffre d'affaires égal ou supérieur à 1 milliard de dollars. Donc, la majeure partie des firmes multinationales. Parmi ces Big Four, on a Ernst & Young, Deloitte, KPMG, PwC. Le rôle des Big Four dans l'évitement fiscal n'est plus approuvé après l'apparition des Paradise Papers qui ont mis en exergue des schémas sophistiqués que ces entreprises ont élaborés pour permettre à leurs clients d'éviter de payer une certaine somme d'impôts dans certains pays et de les conduire notamment vers les paradis fiscaux. S'agissant des Big Four, leur intervention dans la sphère publique, on le retrouve notamment en tant que prestataire de contrats de services pour les États. Il s'agit là de fournir des services de conseil, notamment en termes de réforme fiscale, de fournir des études d'impact. Et ce qui est étonnant, c'est que ce sont ces mêmes entreprises qui produisent et vendent des schémas d'optimisation fiscale aux entreprises multinationales. Ces entreprises jouent également le rôle de lobbyistes. Lobbyistes, c'est-à-dire qu'elles tentent d'influencer l'adoption des lois, notamment des législations tendant à limiter l'optimisation fiscale. On peut citer un exemple Ernst & Young qui, dans l'Union européenne, a tenté de mettre un frein au projet d'adoption d'une convention visant à forcer les entreprises, ou du moins à pousser les entreprises à publier les comptes annuels par pays. Et là, Ernst & Young a dit que ça peut contribuer à la divulgation des secrets commerciaux, alors que nous savons bien que ça contribue surtout à faciliter l'optimisation fiscale. Donc, ces entreprises, en plus de tout ça, essaient aussi d'élaborer depuis les années 1970 des normes parallèles aux normes comptables normales des Nations Unies. Également, il y a un lien entre ces entreprises, les autres, et du moins l'État qu'il faut souligner, c'est-à-dire le mouvement de travailleurs. Il n'est pas rare de voir ces entreprises fournir, les personnes qui fournissent les services à ces entreprises se retrouver en tant que fonctionnaires de l'État ou des fonctionnaires de l'État qui démissionnent pour se retrouver au sein de ces entreprises. Là, vous avez des exemples de schémas d'optimisation fiscale qui ont été élaborés par ces différentes entreprises. On peut citer par exemple PwC qui a permis de contribuer au fait que l'Irlande devienne un paradis fiscal qui permettra à certains de ses clients d'importer leurs capitaux, notamment d'échapper aux impôts dans d'autres pays. Il y a des clients tels que Google, Starbucks, Amazon, par exemple. S'agissant des banques et des centres financiers, la question cruciale qui se pose là, c'est celle du secret financier. Le secret financier qui est le refus de communiquer des informations cruciales aux institutions étatiques, notamment à l'administration fiscale, voire à la police. Pourtant, ce secret financier contribue à une certaine confidentialité qui amène le développement des flux financiers illicites, de l'évasion fiscale, du blanchiment d'argent, d'autres activités illicites telles que les ventes d'armes et de drogue, voire carrément le terrorisme, le financement du terrorisme. Un fait inquiétant, c'est le récent intérêt des États africains pour la mise en place de ces centres financiers. Il faudrait dire que les décideurs politiques aussi ont leur rôle à jouer. Ils jouent un rôle notamment déjà en termes d'élaboration de législation fiscale. Car s'il y a optimisation fiscale, c'est bien parce qu'il y a des failles dans la législation fiscale, sachant que l'optimisation fiscale consiste à utiliser les failles de la législation fiscale pour minimiser le montant d'impôts à payer. Par ailleurs, il y a les incitations fiscales, les exonérations fiscales qui sont accordées par ces pays en vue d'attirer l'investissement direct étranger. Nous avons également les négociations qui ont lieu à huis clos entre certaines grandes entreprises et les agents de l'administration fiscale. La corruption. Déjà, la corruption au niveau global, au niveau des décideurs politiques, et la corruption au sein de l'administration fiscale elle-même. Nous notons également le manque de capacité de l'administration fiscale, également le manque de coopération entre les différents États en termes d'échange d'informations. Quelles sont les perspectives, voire les voies et moyens permettant de réduire ou limiter cela? Déjà, les États doivent reconnaître quand même le conflit d'intérêts, l'existence d'un conflit d'intérêts. Notamment le conflit d'intérêts qui est lié au fait que ce sont les mêmes prestataires qui donnent des conseils fiscaux aux États qui se retrouvent à élaborer ces schémas d'optimisation fiscale pour les entreprises. Il y a également le problème au niveau même de l'entreprise où une même entreprise se voit auditée par un cabinet qui en même temps lui fournit des conseils fiscaux, ce qu'on pourrait éviter. Une solution plus radicale, voire dissuasive, serait carrément de punir ces entreprises si l'évasion fiscale s'avère réelle, notamment s'il y a eu un recours devant la Cour de justice où l'entreprise a été accusée d'évasion fiscale, de pousser le cabinet ayant construit le schéma d'optimisation à payer une partie des impôts que l'entreprise devait normalement régler. Il y a également la notion de transparence. Déjà, la transparence en termes de bénéficiaires. Il y a également la transparence au niveau de la publication des comptes. La transparence en obligeant les entreprises, voire les grands cabinets, à publier les schémas d'optimisation fiscale qu'ils élaborent. Également, le fait de limiter les failles de la législation fiscale, donc procéder à des réformes au niveau de la fiscalité. Okay. Du coup, il est bien de proposer des solutions. Ça, c'est un ensemble de solutions que je vous ai présentées qui ont été élaborées par des chercheurs qui travaillent dans le domaine. Cependant, on a beau avoir des solutions pour les mettre en place, ça s'avère être la question la plus importante. Alors, comment cela peut être rendu possible ou qu'est-ce qui peut favoriser cela au niveau des décideurs de politique économique? Ce serait déjà d'avoir une idée de comment la législation de chaque pays contribue au développement des flux financiers illicites au sein du pays. Et c'est ce que notre institution fait en élaborant son indicateur qui s'appelle l'indice de secret financier. Cet indice de secret financier permet d'évaluer le risque auquel est exposé un pays en fonction de sa législation. Il a été développé pour l'année 2018 pour 112 juridictions, dont 9 pays africains. Il repose sur des sources fiables telles que la législation et aussi des rapports publiés par de grandes institutions. Cet indice a deux composantes principales. On a déjà une composante de secret financier que nous élaborons à partir des données que nous collectons. Également une autre composante qui représente la part de chaque État dans les flux financiers. Donc cet indice est élaboré à partir des 20 indicateurs suivants. Je ne pourrais m'appesantir sur tous ces indicateurs vu la contrainte de temps, mais là j'ai sélectionné les principaux indicateurs qui ont trait au thème étudié aujourd'hui, notamment l'indicateur de secret banquier, et la capacité de l'administration fiscale, la divulgation des comptes pays par pays et l'échange automatique d'informations. Là, vous verrez les résultats des 9 pays qui ont été introduits dans notre échantillon. Je tiens à souligner que nous allons agrandir le nombre de pays dans l'échantillon, notamment de pays africains francophones. Il y a le Kenya qui se retrouve en tête. Nous ne disons pas que cela peut avoir plusieurs causes, notamment l'adoption du centre financier de Nairobi. Nous ne disons pas que ce centre est à l'origine de l'évasion fiscale, voire de l'optimisation fiscale directement, mais ce centre peut être utilisé par des agents au comportement douteux qui peuvent s'en servir pour développer leurs activités illégales, d'où le fait que le risque soit accru pour ce pays. Vous verrez sur le site de l'indice de secret financier un certain nombre d'informations telles que des rapports par pays. Également, pour un souci de transparence, nous avons mis en ligne toutes les données que nous avons utilisées pour notre analyse. Vous pourrez avoir d'autres informations en vous connectant sur le site de notre organisation. Je vous exhorte également à suivre le documentaire que nous venons récemment de publier sur comment la Cité de Londres et contribue à l'optimisation fiscale, voire aux flux financiers illicites, et comment des pays comme les Bermudes, les îles Caïmans sont devenus des paradis fiscaux. Je vous remercie de votre attention.
Thank you very much. Oh, goodness, that could have gone worse. So now I'm going to introduce our second speaker. As Maimuna has just set out, I think a number of really important questions about the role of auditors and their double role as advisory firms, the problematic nature of confidentiality, and so also, of course, behind all this is the role of multinational corporations. Dominic Brown, forgive me, is a activist, and he works as well at the Alternative Information and Development Center, where he heads the program on economic justice, and he focuses a great deal on dimensions of political economy and political ecology. But I understand as well that you conduct investigations, and so what I'd invite you, Dominic, to talk to us a little bit about here is in keeping in mind what Maimuna just described, how we can challenge in the way that you have through your investigation some of these practices, expose them, and ideally stop them.
Thank you. I'd like to start off by saying that I really appreciate being here amongst very knowledgeable people. Initially, I set out to speak about 6 rough points. The one looking at the opaque nature of activities of multinational corporations that exist by design, and 2, to speak to how this is to avoid and evade paying their fair share in taxes, but also in wages. The third point is that advancing all of these practices are the enablers, which includes the banks, the lawyers, and I was hoping to concentrate a little bit on auditing firms, looking at the connection between auditing firms, multinational corporations, and aggressive tax planning. Before looking a little bit at the double speak of auditing firms, particularly the big 4 who operate with complete impunity, and then drawing some conclusions and looking at some policy proposals. So I think a lot of these things, I just wanted to make some points on these things before addressing your question directly. So I think that we're all aware of how much resources leaves Africa. Africa is a net exporter of wealth, and a lot of this is, and the sustainability of this is through aggressive tax planning, whose schemes are made up by auditing firms and lawyers, etc. And just to let you know, the big 4 auditing firms, in fact, audit 99% of the 100 biggest companies in the world. And they are expected to find loopholes within taxation legislation and so on. And as a result, we're seeing the growing power of multinational corporations. In 2016, in fact, there was a report that indicated that out of the top 100 economies in the world, 69 are corporations. I mean, that's quite telling, which gives a sense of the shift in power from people, even from nation states, to these multinationals. And I think there's a key link between the role of the big 4 auditing firms and the size of subsidiary networks related to multinational corporations. The multinational corporations who use these big four auditing firms have considerably more subsidiaries in these networks of tax havens to create this complexity and opaqueness. And so when we speak about gatekeepers, I think it's quite apt. But I think there's many gates, not just one gate, because the minute you open one gate, there's another one and another one. And we never really get to what's behind all of these gates. And this is intentional. It's not by accident. In 2012, it was estimated that between 21 and $32 trillion was in fact hidden on tax havens. I mean, this is an enormous amount of money that can be used in substantial ways to address issues of inequality and unemployment, particularly in developing countries on the African continent. I just wanted to say two things in relation to this, and that is that I think it's important that we see this. I think in the earlier session today, it was speaking about this within an international architecture. I think this is critical because as a result of the global economic architecture, I think we're seeing two things. And that is, on the one hand, we're seeing states forced to compete in this corporate tax race to the bottom. And so over the past 3 decades, the average global corporate income tax paid by corporations decreased by more than half, from 49% in 1985 to 24% in 2018. And I'm sure, as many of us are aware, the USA has been the latest to reduce their statutory corporate income tax rate. And so the globalized economy, in fact, rests on this dual shibboleths that GDP growth is a measure of societal growth, and that foreign capital is an essential condition for this growth. And this ultimately leads to extreme competition between countries to attract foreign capital, and this is why we call it the global race to the bottom. It's where taxes are the lowest. But at the same time, I think we also know that this creates the whole architecture behind which corporations can shift profits from places where they employ many workers and have higher tax obligations. And I just wanted to come in here, and this also speaks to the question that you were asking. And I think in addressing, one of the main ways that we can address the issue of illicit financial flows, capital flight, and tax evasion. Earlier today, I think it's Dr. Jamal spoke about the importance of building a hegemony. And I think this is critical because we can't change the system, because this is a system that underlies all of these practices that we're seeing today. And we cannot change that by the soundness of ideas alone. We need to change it by building power, a counterpower. And through our work, we have shown that, I made this point in the previous session, that as a result of illicit financial flows, we're not only seeing the reduction in the tax base, but in countries with huge unemployment, but also huge wage inequality, you see that the illicit financial flows actually perpetuates this. And I can illustrate this by way of an example. If a corporation, I'm not sure what the statutory corporate tax rate is in Kenya, but in South Africa, where I'm located, it's 28%. Now, if you want to shift $28 million out of the South African country, the corporation needs to move $100 million to a tax haven. Now, if that $100 million was kept in the country, 28 million would go to tax authorities, but there's a remaining 72 million. This is almost 2/3 more than the amount to avoid paying taxes. Now, if that 72 million stayed within the country, wages would be able to access this in collective bargaining councils, which means that workers can demand improved wages and better working conditions. Now, this is extremely important for two reasons. One, workers, I only have 3 minutes left. Workers are critical in being able to build a counterpower. But the other reason is that if you consider the issue, and the issue behind all of this is this opaque nature through which these corporations operate, then workers are able to help addressing this through demanding the financial statements of subsidiaries, not only the mother bodies of corporations, but the subsidiaries of corporations. And this goes a long way into uncovering and showing and giving light to the opaque and secret nature through which corporations actually practice. And it is through this way that we in South Africa have actually been able to take up a massive case against Lonmin Mining. Now, many of you might not know the exact corporation, but I'm sure many of you know the way they work. So in 2012, workers went on strike at this mine, a platinum mine in South Africa. And they were demanding an improvement in their wages. It was a wildcat strike, unprotected. And essentially, what they did through this process was, or out of this process, the Lonmin PLC, the mining company, refused to negotiate with the workers. And this ended in a bloodbath where 34 mine workers were massacred on the 16th of August, 2012. And out of this, a commission of inquiry was set up. And one of the main things out of the commission of inquiry was that Lonmin had to show, they had to open their books to us to prove, because the reason why they did not want to negotiate was because they claimed they couldn't afford it. And the Farlam Commission, the judge's name was Farlam, said, you have to open your books to show that in fact, and prove that you were not able to afford this. And through this process, AIDC, the Alternative Information Development Center, was given the task of investigating this. And what we found was, of course, that Lonmin was shifting profits through transfer pricing, paying of management fees and sales commission fees to hundreds of millions of rands every year. And these could have dramatically improved the lives of workers in South Africa. Now, it's through these processes that we think we can go a long way in addressing the secret nature on a case-by-case basis, showing the way these corporations operate. So I had a lot more to say. I just want to make one concluding remark, and that is that outside of how we can address the issue, in South Africa most recently, we've seen the impact that these auditing firms have on addressing development within the country. I think it was important, someone was saying this is a development issue. And I think that's important in terms of being able to build a counterpower as well, in mobilizing people. South Africa has been negatively impacted by the dubious work of KPMG, and this is in one of the most extreme instances, was where KPMG in fact delivered flawed reports which said that in fact there was a rogue unit, a unit that was set up illicitly within our revenue services. Afterwards, they admitted that the report was a mistake. This just happened 2 weeks ago. The report was a mistake, and the conclusions were wrong. But ultimately, the damage had been done, and a once reputable revenue service is now a mere shadow of its former self. Its reputation and its capacity completely dismantled. And then once again, in this past weeks, we see another one of the many scandals of KPMG in South Africa, who have in fact okayed a flawed financial statement that allowed millions, over 100 million rand, to be siphoned out of municipalities and from other vulnerable people, including pensioners. And so we can see that the role of the auditing firms is not just about enabling the practices of illicit financial flight. In fact, they've become so courageous about their work that they completely do not care about inciting corruption within the state and within state enterprises. Thanks.
Thank you very much. So now I'm going to pivot a little bit to another major component of these enabling professions, and that's the legal profession. So I should probably, at this point, as we're talking about transparency and conflict of interest, point out, A, who I am. My name is Sargon Nissa, and I'm the director of the Financial Transparency Coalition, which includes Donald Dea as director, of course, of the Pan-African Lawyers Union, and of course our hosts, the Task Justice Network Africa. So just before I ask you a question, Don, let me tell everybody else a little bit about you. Donald is the Chief Executive Officer of the Pan-African Lawyers Union based in Arusha, Tanzania. He was previously Chief Executive of the East Africa Law Society, and before that acting CEO of the Kenyan section of the International Commission of Jurists, and Deputy CEO of the Law Society of Kenya. If I gave you every single bar association, society, lawyers association with which this man is a member, Brian would probably storm the stage. So we won't go into that, but trust me, he knows of which he speaks. So I'm going to pose you a challenge, Don. In the spirit of what I said in the opening, how do we turn some of these gatekeeper professions from what's been described quite compellingly as enabling of illicit financial flows into what one of the speakers this morning said, they should be allies. This is a profession, you know very well, that somebody doesn't reach the bar unless they are unless they are able to meet strict ethical standards and guidelines, and there's expectations about how legal professionals must behave. So my question to you is, with these ethical standards and obligations, what do you see the prospect for the legal profession in terms of transforming from an enabler into an ally?
Thank you, Saigon. I think a lot of things could be said that could be done, a whole list of things, but in the interest of also democratizing the conversation, I will stick to only three very brief ones. One, when introducing this session, Brian Kagoro spoke about the importance of diversity across professions, occupations, trades, and disciplines, and I agreed with him. And I would urge that perhaps we also look at the importance of diversity within professions, within occupations, within trades, and within disciplines. One of the things that I've noticed working with lawyers and lawyers associations, principally in Africa, but it happens in many places, is that the elite are the same. So you'll find that it is a top-tier law firms, and I believe the same happens in the accounting profession. Some of the stories that Dominic and Maimoon have been saying, the elite within the profession represent the elite businesses. They also represent the top of government. And you can very easily get yourself to a situation such as what is given in KPMG, and colleagues in Europe gave us the same story, talking about the same big firms, that they advise OECD that's setting the rules at the regional level. They are the same ones that advise the member states when they're translating this into law and policy, and then the same ones that advise the big multinational corporations. Same people. So you can easily get yourself into a situation whereby you tweak everything to just suit your interests or your client's interests. I think like what Dominic has been telling us. So part of what we need to look at is the possibility of raising up the voices of others within the professions so that there's a balance. So, because you'll also find, for instance, these same elite that represent the top businesses, the top governments and so on, are also in the leadership of the profession. So they're also the ones setting the rules for the profession. And even then, you can see how then the rules can be tweaked to suit them. So I think one important thing is that. A second thing that I would say is the issue of law. When we talk especially to our members, and I think this happens to many, they say, look here, my ethical duty is to represent my client, my individual client, not all clients in general and all society in general, to represent my client to the best of my ability. So that's my focus. So let the other people go get their own representation, and then we deal. So that calls to diversity. But it also means then that perhaps what we need to do is have much simpler, but also more comprehensive laws being passed, so that we turn what is currently purely unethical or maybe immoral into illegal. Because in this field where we have, or in a sphere where we have vague laws with lots of incentives and lots of gaps and so on, is the field whereby then in advising, and again, you're the same one who helps in write the law, you then create all these loopholes. That means that in the end, you can claim that you're acting ethically, and you're not. But I think thirdly, there's also, I think, a lot of role. That's what I want to say, not to speak too much. I mean, yeah, there's, I think, still also a lot of role for hard-nosed advocacy, especially when there's diversity within the professions and so on, that you'll have other people that will really do a name and shame rule, you know, and can really use, in our own context, can really use things such as public interest litigation, freedom of information litigation, access to information litigation, and so on, to try and level the field and at least try and cause people to act a bit better. Thank you.
Thank you very much. So I'm going to turn to Dr. Valerie, and forgive me, Nkechiku, who is the assistant professor in law. So you see where my question is going to be focused upon. Focused on financial regulation and corporate governance, and the doctoral candidate at the University of Warwick. Is this correct? I heard a noise from you, and I was suddenly having a panic. And you are also teaching assistant in the area of financial and business regulation. So a more comprehensive perspective I don't think we could enjoy today. So I want to ask you a question where I might come out looking rather poorly here. Is the question I asked Donald realistic? Are me and many of my colleagues in civil society and the advocacy community naive to demand that the legal profession, and Donald gave us a very compelling example, naive to demand that the legal profession solve the problem of illicit financial flows for the rest of us when they have a confidentiality agreement with clients?
Now, it's a yes and no answer. I wouldn't say yes, because basically I know that within the legal profession, the attorney-client privilege is very sacrosanct. So what this means is that lawyers... Okay. So basically, within the legal profession, you have the attorney-client privilege, which is basically saying the attorney is to ensure that whatever his client discloses to him is kept confidential. So, and this is a very sacrosanct rule, should I say, within the legal profession. Now, when you look at the FATF, what the FATF, or FATF as people call it, is saying is that lawyers are to basically carry out customer due diligence on their clients. They also ask lawyers to report suspicious activities by their clients, especially if a client comes forward to tell you, I want you to move money from point A to point B, and then I want it to be done in such a way that is complex, that is not traced back to me. So in that case, they want lawyers to raise an eyebrow and be like, no, we're going to flag this up and report it. And then they also want you to uncover beneficial ownerships, because usually the lawyers can, in some instances, stand in places of their clients and then cover up beneficial ownership. So what this is basically telling us is that they want you to report your client. Now, is this realistic? Now, ethics and morals will tell you that, yes, it's somewhat realistic, and even the accountancy ethics body has said it is very realistic. When your client does something, or when your client is asking you to go into shady deals, please report it. That has been instituted by the Accountancy Ethics Committee, the international body responsible for that. But for some reason, you see that for lawyers, we're reluctant to do that. And the question is, why are we reluctant to do that? We're basically reluctant to do that, one, because every client deserves representation. Now, if you, for instance, say you're going to report every client who comes to you to tell you, I'm going to do this, or I have done this, then you're basically saying, my client doesn't deserve representation. Now, it might seem very unethical to say, but then if, for instance, you have a criminal who comes before you, and the law tells you you have to represent that criminal, would you then say, no, he stole a bag, or he murdered someone, so because of that, he's not entitled to legal representation? I think it's a bit dicey to say that, because someone has to represent that client either which way. Now again, there's also the issue that it goes against the right of self-incrimination. So let's take, for instance, a lawyer goes forward to to report his client, that his client has done a particular thing, has committed a particular crime, or is about to commit a particular crime. In the course of reporting that client, he might then go further than what he's legally bound to say, and in that case, he's incriminating his client, which in that case is basically going against the ethics of his profession. And then lastly, you then see that it opens floodgates. If, for instance, you're saying report your client for money laundering issues and tax issues and corruption issues, you then see people saying, when your client tells you, I committed a crime, please report the client. So where do you draw the line? So for these reasons, it is questionable whether lawyers or what roles lawyers can really play. But then again, there are exceptions to this. Because for instance, if it's in breach of law and the law has required that you report your client, by all means, please report your client. Again, if the client wants to commit fraud, it is required that you report your client. But the question is, what is fraud? What is money laundering? Where do you draw the distinction between fraud and other financial crimes? Now, again, it's very jurisdictionally based and depends on how a particular jurisdiction determines that. So in that sense, I would say that the onus should not necessarily be on the lawyer. It should rather be on the prosecutor and the regulators to do a good job in unearthing the money laundering issues. But then again, going back to what Don said, I would say that the international bodies or the international professional bodies have a role to play. Now, when in the process of investigation, the prosecutor or the investigator find out that a client has actually committed a crime and he's been aided by the lawyer, the question then becomes, what do you do to that lawyer? In the case of James Ibori, who was the former governor of Delta State in Nigeria, it's a very infamous case. I'm sure everyone here must have heard of it. What happened in that case is that his lawyer had gone ahead to bribe an investigator to cover up his tracks. That was found out. His lawyer just basically went under for a few years, maybe, and then came back and is now one of the leading litigators in one of the firms in the United Kingdom. So it then begs the question, to what extent can we say lawyers should step into the arena? And there's also a responsibility on the International Bar Association, for instance, to basically say, in that instance, we have an adjudicatory framework. We want to call that lawyer into questioning, and what we want to do is to ensure that there is a ban that will tarnish his reputational image and keep him away from the legal field forever.
Great, thank you. Thank you. So we've had two very interesting legal perspectives which have probably complicated the matter further, which is what I usually find happens when I've spoken to a lawyer, to be honest with you. But we're going to turn back to the accountancy profession now. You were one of the few, Jared, who raised your hand when we were asked how many accountants are in the room. Let me introduce you first before I pose my question to you. Jared Maranga is the policy lead in charge of the Tax and Investments Program at Tax Justice Network Africa since August of 2016, and has vast experience on tax and investment advisories, including domestic tax, international tax, and transfer pricing advisories, as well as being, as his hand in the air indicated, a certified public accountant of Kenya, and also a certified monitoring and evaluation professional. Now, the question I want to ask you, Jared, goes back to the points that were raised in our first two contributions, which is to say the role of these big four industries. Now, has anybody here in this room been to London in the UK? Speaking of, tax havens and illicit financial flows, I'm sure some of you have. I see some people nodding. If you go to the City of London, you can find a very interesting building, which once I put on a suit and entered, and it's very easy to do so if you put on the right threads. And that building is the headquarters of the Institute of Chartered Accountants of England and Wales. And what's very fascinating about that particular building, which dates from the 1800s, is that you can walk up the staircase and see very, very plush paintings of old, long-dead white men called Mr. Price, Mr. Waterhouse, Mr. Coopers, Mr. Ernst, Mr. Young. These institutions have origins, and they're real and tangible, and they didn't just come about out of nothing. So there was a very revolutionary, from the perspective of that institution, proposal made by Maimuna in her presentation, which was to challenge the very business model of these institutions, which are both auditing and auditing is a little bit analogous to legal profession, where there are obligations and ethical considerations of the auditors, and advising. Maimuna argued that that should be separated. What do you think about that? Can we address the problem of the Big Four through such a simple but revolutionary approach, or is the problem more complex in your view?
So thank you very much for the introduction. I think it's a tough question you've asked in terms of if we need to separate the service offertory from the Big Four. But maybe before I go to that, let me just try to highlight quickly what it means of accountancy. At least maybe it can help us to understand where the auditors or the Big Four comes in terms of, if you realize, maybe I can ask each of you, maybe you came from your organization, you could have been facilitated in one way or another, and I believe you could have passed through the accountancy department. So what happens there, I think, is the source of the information that you end up seeing in the public in terms of maybe findings or audit reports, or what you have as advisory reports based on the financial information. So the essence, maybe what we need to take into consideration is we need to break accountancy into its basic disciplinaries, so that we can be able now to try to check where is the weakness. And probably if you want to fix this weakness, you can easily tell, is it at the ultimate where we are going to get a statutory audit? Is it the source of information where the information has been captured? So then from there it could be easy. Because if you realize some of the scandals we have maybe heard of, either they have been told of by accountants and they have been influenced or caused by accountants. So you realize there is a conflict even within the profession itself that needs to be checked, so that you can be able to address the issue effectively and efficiently. Going straight into the question of if there could be need for us to separate the advisory services and auditing services, I think my answer could be yes or no, depending on how you're going to look at it. Number one, if you talk of advisory, what kind of advisory services are you looking at? Because advisory services can be broken into so wide in terms of financial issues. So therefore, when you're looking at advisory, you want to look at how maybe is it going to conflict the other offering in terms of either auditing. Then you can say there might be need to separate if it's going to conflict the independency of this other offering. But if that is not going to happen, then you realize it's going to be a challenge. Because as you may understand, accountant's profession is a well-regulated profession. There is requirements of independency, which needs that if you're going to carry out audits, there are some services which these firms might not be required to offer to the same client. But sometimes this is breached in terms of the desire to maximize wealth. And that's where we realize we have some of these conflicts. But if we follow the ethics as they're regulated, then in my opinion, to some extent, some of these issues might be mitigated. And then we can be able to address. But another challenge which might come in terms of trying to seek us to separate this profession is that, one, some of these services feed into one another. Consider auditing. Auditing itself is not just looking at numbers. We have control systems that needs to be looked. We have forensic services that needs to be looked at. But you need to have all these professions within a team so that you can be able to break them down in a way that it's easier to say there is a breach of process here because you have an expertise in forensic, which probably somebody who is having general accounting knowledge does not have. So therefore, in my opinion, from a perspective, then it's not going to be very productive if you break them down. But again, if I go to the yes answer that they can be broken down, is that looking at the issue of independency. If you're going to break them down and have auditing, have probably other advisory services being rendered from different organizations, what that will mean is that there will be like an oversight over the other. In that if you have firm A auditing, then you have firm B going to provide, like, let me say, financial transaction advisory. Then you'll have maybe the auditing firm going to look deep into this transaction to make sure that it's done in line with the requirements. But if it's done within the same firm, there is likely to be complacent in terms of we did this And probably if we are going to expose ourselves, then it means either we are going to shoot ourselves in the foot and we are not going to make any progress. So in that situation, then you find there's confliction. So splitting them can help in terms of check and balance. But again, as I said, we need to note that these services build onto one another. And then having a rich team that is going to look into these financials is going to give a rich report that is going to take an all-round consideration of all the issues. That is maybe what I can give in terms of an opinion, whether we split or we don't. Thank you.
Thank you very much, Jared. So can I just clarify, when I asked you a question, you said yes and no, and you told me you're not a lawyer?
Sorry, I think if you look at taxation itself is law. So in my opinion, reading the tax laws qualifies me to be a tax lawyer. But I don't want to join the bar, so I think let me use the quotes to justify my legality of being a lawyer.
I think it's all being recorded, so it's too late, Jared. Thank you very much. Now, I have to check in with our Master of Ceremonies, Brian Makuro, here in the front, about how long we have left. 13 good minutes, none of those ordinary ones. Now, I'd originally asked our panelists to, in listening to each other's contributions, prepare a question. But before I do turn to them, can I just see how many people would like to use the remaining time?
So let's be democratic. There's a lawyer who's threatening to sue me if we don't extend it to... It's your break. So we can either take 20 minutes or 30 minutes. It's the end of the day. We don't want to impose. We know there is a launch soon after at 6:30. So just want to get a consensus. Those who are saying 20 minutes, show of hands. Sorry, 30 minutes discussion, show of hands. 15 minutes? 15 minutes discussions, show of hands. So maybe the midpoint is to go 15 to 20. Is that okay?
So what was the conclusion there, Brian? Thank you very much. Okay, so if I may, I know, Dominic, you already indicated you had a point you wanted to make. If I could invite questions, do we have the roving mics? And we're just going to take one round of 4 to 5 questions. Can you raise your hands up in the air, please? And then there's a gentleman here in the gray suit. I saw you go first with the other hand. So that table, I'm afraid the rest of you are out. But what I would like to do first, and this is a rule I always apply when I'm moderating events, is to ask our sisters to ask the first 2 questions and our brothers to wait, because we, in our day-to-day lives, get a lot more opportunity to speak. So I see one there and another one waving happily there, and this gentleman here. So if we could go 1, 2, 3, and then 4, okay? And 5 over there as well. Thank you very much. So if we could pass the mic. And then we're going to get all the questions together, and then I'm going to turn back to you in the interest of time so that we can meet the democratic agreement that was achieved. Go ahead.
Thank you. I'm not particularly warmed up to the law profession, and listening to the answers from the lawyers this afternoon just confirmed it. It's just, you just ask yourself, so what are we doing here? You know, it's like there's no hope. So, Dawn, you gave a bit of light to it in your normal activism. So maybe this question will go to you. Why are we playing the game according to their rules? Because that's what we've been doing from Ghana 1957. It's their rules, it's their terms. So, and I like the name of your organization, that's why the question is to you, Pan-African Lawyers Association. Can't we come up with our own Pan-African rules? In fact, we should. It's high time we do. What's stopping us? Because just waiting to play this game according to their legal rules, they wrote these rules knowing, because imperialism is not new. It's always been there. So they wrote them, excuse my language, knowing that they want to screw us anyway as a continent.
I challenge all the other questioners to have a question as direct and unambiguous as that one. Thank you very much. Is the mic?
Thank you very much, Mr. Moderator, for the inclusion lens. I'm Abna Fari. I work for Christian Aid in Ghana. And my question goes to Dominic. Dominic, given the rhetoric about the capacity of our taxmen sometimes to decipher or to track some of the issues in relation to IFFs, it's difficult sometimes for them to track the complicated transactions. There's the use of derivatives by MNCs. We have tax avoidance and the whole array of them, and sometimes our taxmen are unable to track them. I was wondering if there's any collaboration between firms like yours and government, given the capacity gaps we find, and if there are any pro bono services we could tap into. Thanks.
Okay, I'm Benedict from Ghana. I work with Ghana Integrity Initiative. Gerald, thank you for the explanation you've given about the operations of the audit firms. The issues that comes to mind readily has to do with duty of care and negligence. And how do we, based on these two key issues, to take legal action against these firms? That's the biggest question we need to be looking at. Once you can establish duty of care, and you can also establish negligence on behalf or on the side of these firms, then you have room to litigate. And the question is, how many of us are ready to litigate? There are too many issues that leads us to talking. If you do the talking outside, but action or legal actions are required and you don't take the legal actions, then there will be no results. And so once we can establish duty of care in connection with these standards that are established for the firms to comply with, if there is negligence along those lines, then we as a network or as a group would have to begin to take legal actions. And so that's one thing that I want to point out. Do our institutions have the courage to take legal actions if the need arises?
Thank you very much. We come here, please, and then there's a gentleman in the back, and then I've been pleaded with, and she's quite close to me, a final question here, but it will be brief, will it not? Go ahead.
Ouais, merci pour la parole. Je m'adresse directement à Madame Diakité, dont je suis attentivement l'intervention. Madame Diakité, à travers votre organisation, vous faites une accusation très claire et très forte sur ces grandes que vous avez appelées Big Four. Je voulais savoir quelles sont les actions que vous avez déjà entamées au niveau de votre organisation du point de vue des sensibilisations, signifie être en contact avec ces grandes pour les empêcher ou accuser ce qu'ils font. Ou bien, si avez-vous entamé des actions juridiques à travers votre organisation contre ces grandes firmes qui manifestement sont en train d'empêcher le développement de l'Afrique sur ce point aussi précis. Merci beaucoup.
Thank you. My name is Tola Onoyemi, the Nigerian Office for Trade Negotiations, Assistant Chief Negotiator. My comment is more along the fact that I didn't hear a lot of conversation around the role of international activism in addressing holding gatekeepers accountable. So we all know the popular Rudolph Elmer case, the WikiLeaks case that got handed over 2 CDs to William Assange in 2008-2011, and was held guilty by the Swiss court of breaching Swiss secrecy law. Just 8 days ago, it was acquitted on all counts because, according to the High Court of Switzerland, he's not held accountable for Swiss secrecy law because he was working in the Cayman Islands. So that's a very interesting hole, and that's one of the biggest holes that's been able to be punched in Swiss secrecy laws, particularly around banking and taxation in the last few years. So I think international activism provides a very big gap for holding most gatekeepers accountable, mostly because most of the laws are domestic to their jurisdiction. So if you play across jurisdiction, it actually opens a new gap that no one has really explored. I just thought that was important to mention.
Could we have the mic at the front table here, please, as well, for the final brief question? And then we'll turn to each of our panelists in turn, and I invite you to select, not try and answer every single question. I think some were directed at individuals, and to be selective and sum up as well in your final comment. Go ahead.
Okay, so I'm a lawyer, and I was a practicing lawyer, but decided to become a social justice lawyer at a certain point. And so this is directed particularly at the two lawyers, because this thing about the right to legal representation really had me thinking. And I asked myself the question, and now I put it to you. What is the ethical obligation and the duty of a lawyer and accountant when a client comes to you and says, I would like to plan the murder of my wife? How can I do this and get away with it? Should I employ the services of a hitman? Will that be easier for me? How do I manage to make sure she dies, I get the insurance, and I don't go to jail? And then you sit quietly in your office, you do the research, and then work out a system for that person. And then when that person does get caught, you then say, I have the obligation or the duty to attorney-client privilege, it's really a privilege relationship between me and my client. I've been through ethics. 25 or 29 years ago, as an advocate, and I can tell you that would be unethical. I should be disbarred for that. When you cross-examine a client, a witness, and you know your client is guilty, you cannot put to that witness anything that demonstrates that you think or your instructions are different from that. So let's be clear what we're talking about here, okay? Thank you.
Thank you very much for a challenging and provocative final question. So as one of the lawyers, Valerie, I'm going to turn to you, and we're going to work our way back to Maimuna. So you're going to enjoy the first and the last word. Go ahead.
Okay. So first, I'll address the statement made earlier. And basically, the lady was asking why we can't have a Pan-African law on IFFs. And I would say one of two things. One is that countries cannot be regulated in isolation, basically because IFFs involves money moving through different countries. So if every country or every continent should say, I want to regulate in isolation, what you then leave is that you leave a gap between countries. So who regulates that space? So it raises a lot of questions. And secondly, what you realize is that, yes, we have had movements that have tried to kind of bring it back home. Say we want to have, like there's the African peer review mechanism by the African Union. And what they basically try to do is to say we want to regulate money laundering and corruption. But when you look at the documents and you look at the details, what you then see is that they were basically copying and pasting statements or guidelines or recommendations from the FATF. So in that sense, you then ask yourself, how domesticated is this? So that's something you want to also consider. They were copying from the FATF, that's FATF, the UN, and all sorts of documents, basically consolidating it into one. So yeah, you can push for it, but I'm going to tell you it's going to be an uphill task. Now, secondly, she asked a very interesting question. I think one that has almost trapped me. So one of the exceptions to client attorney confidentiality is when your client wants to commit a crime. Now, this is usually stated within the context of, let's say, criminal law, like the example you gave. Then it then takes us back to why gatekeepers do what they do. Now, there's a reason behind it, there's a motive behind it, and then gives you the different various.
Asha just pointed out that was probably the Bar Association.
So there's a motive behind it, and the motive.
Please use another word. Don't use motive.
Okay. Motive. Okay, so there's usually, the motive behind it is usually financial. Like, if you ask a reasonable person on the street, because we use the reasonable objective test, why would you support someone who wants to commit murder, or would you support someone who wants to move money? Chances that they will tell you, no, I don't want to be involved in murder, but if he's moving money, what's my cut in it? So basically, you then see that the move is, yes, it's crime, but then it's like, I'm getting something out of it. If I help you kill your wife, are you going to pay me? And how much are you going to pay me if I'm going to be behind bars? Or if I help you move money, I know the laws, I know the institutions, I know the judges, I can get my way out of it. I can use the loopholes in the law to basically exploit the system. So I think there are two very different things, and kind of bringing them together kind of obscures the real intention behind client-lawyer confidentiality. Does that answer your question?
We still have another lawyer, so don't worry.
So thank you. I think there was no direct question directed to me, but I'll just mention one fact. As the way the global economy operates is we are a capitalist economy. So one thing maybe with capitalists is that there is an aspect of maximizing returns. And one of the drive is how to maximize wealth. So probably the reason as why I'm saying that is that you realize some of the questions you have asked in terms of ethics, it's something that drives the compromise of ethics. In maybe when you're doing something professional. How much return you're going to get out of that compromise mostly drives how much you're going to be involved in that kind of compromise. So then it gives it a challenge. But then, just to mention on the aspect of integrity, I think I'm giving an example of a recently enacted Finance Act of Kenya, which has tried to provide for sort of a protection to accountants in terms of resisting the harassment that you get from your client, employer, or else your supervisor. In terms of disclosing information that you feel in line with integrity is not supposed to be done in that way. So that one in itself is a plus, because then if we had an accountant who felt that the kind of practices probably my employer is engaging in, then disclosing that one will be a plus, because then you could be realizing that this is a loophole that has been overutilized in terms of now concealing the necessary information, because this accountant probably is fearing what is going to be the implication if I'm going to disclose such kind of information. So some of those practices, if they are maybe copied in other jurisdictions, sometimes they help in terms of getting to realize that the accountants, as I said, in fact, most of these corrupt deals or corruption issues start from within. So from your organization, you might find there is some instances of bribe that take place in that. And mostly you find the accountants are involved. So therefore, if we manage them from that level, then coming now to the professionals who are going to audit or do that, then it will be very easy, because some of these things could not be even in the line of them to review. So anyway, just to conclude and maybe say is that what we need to take note of is that the accountancy profession is very integral in enhancing good governance systems in African countries.
Thanks. And again, trying to keep it brief, you can't answer everything. If I look at the question asked by Kanyisile Litfield Chabalala, who asks, why do we follow rules that were set without us? You're talking about how the UN works, which African state can say that it actually really participated properly in defining the UN Charter. If you talk about the WTO, if you talk about the laws around the Bretton Woods institutions, if you look at the current context where rule-making in this field that we're talking about, the most influential player is OECD, in which we are at best the rural cousin allowed into the room during the negotiations. I think that question, Kanyisile, is not so much a question for lawyers as a question for all of us. Because the question that you're asking is a question of reform of the international institutional architecture. the international institutional architecture generally, including the UN, and also the international institutional architecture in the field of economic governance, in the field of trade where we are. So I think the answer for us as Africa and the answer for us as a world does not necessarily lie in the law. It lies on how we hold ourselves accountable, that if we take positions, we don't then get bribed with 30 pieces of silver and play the divide and rule game ourselves when we've got a common position. Because the problem is we never really, as African states, stick to our common position. So I don't think really it's in law there, it's how we leverage our power. The question asked by Asha Ramgoben and the example that you gave, again, for me, I think personifies, there's never time to say everything, but personifies the point I was making between the gap between the immoral and the illegal. The examples you gave are examples which, if a lawyer engaged in, that's criminal. Crimes of conspiracy, crimes of failure to report crimes, all those are crimes. Our penal code is quite clear. Somebody is going to do this nature of crime, you know about it in advance, you do not say that's criminal. The problem with some of the things that we're dealing with in this room, and I know it's a bit of an oversimplification, but some of the things we're dealing in this room is that where you are immorally exploiting gaps in the law that were not really designed for you, or which, from the examples I gave, you have unethically or immorally designed for your client, you know, and so on. So it is not clearly legal right now, it is moral. So what we need to do is to simplify as well as strengthen laws. And our colleagues like from TJNA in this field are always giving that example. Make tax laws simpler, but also more comprehensive. So it is quite clear what is your duty to report, the CBCR, the country-by-country reporting, and so on. The laws around beneficial ownership. Once the country makes it clear beneficial ownership must be known, then a lawyer has very little leverage to hide in a multitude of trusts and shell companies and so on. So I think it goes to reinforce the same example we're giving. That is about how we engage in strident advocacy. And let me finish on that, and that's the point that the brother at the back made. The problem I have with African lawyers whom I serve is their sheer lack of imagination and creativity, especially social justice lawyers, in what can be done, even using the laws that we have as imperfect as they are. You are very correct to say that the field of public interest litigation is completely, I mean, some stuff has been done. If you look at the stuff, for instance, that Treatment Action Campaign was doing 20 years ago, litigating economic, social, and cultural rights, a lot of us were looking at them in shock. But they made precedent. If you look at the stuff of SERAP, the Social Economic Rights Action Plan, and the stuff that they've been doing over the last 20 years. So we can be, if you look at the stuff that Southern African Litigation Center does, TJNA here has sued the Kenyan government over the double taxation agreement that is entered into with Mauritius. And it's dragging them through the court process on that. Transparency International Kenya took on the Kenyan military and went and got a constitutional court decision that the military in Kenya must subject itself to audit by the Auditor General, that there's no procurement under the laws of this country that are so secret that they will not be subjected to the Auditor General. So I think this is really a clarion call on us, lawyers and activists, to just be more proactive in using what we have. I know a colleague, and that's the last thing I say, in Zambia, Mutembo Nchito, if you look at his story, he helped combat corruption in his country by just using pro bono representation of people who had been charged with criminal defamation. Journalists had reported stories, they were being prosecuted. He went there pro bono as their counsel and used it to open a whole Pandora's box, and the country got to know of a lot of corruption that the leaders were doing. So really it's about how proactive, imaginative, and energetic we'll be. Thank you.
A tough act to follow, Donald. So a few quick points. The first is, how do you engage with different stakeholders? I think engaging within government is important and at different levels. On the one level, 2 weeks ago, AIDC had a seminar, and at the seminar we had the chairperson of the finance committee, portfolio committee on finance, rather, as well as his advisor. And they were so enthralled by the outcomes of the workshop and the kind of content that came through it. They were saying, please speak to us, make submissions to Parliament, and enlighten us more on this. So we need to find out within governments around in the continent and wherever we are located, where are the pivot points? Where are the weak points where people have an appetite to deal with some of these things? It won't be every department. The point is to find the ones that you think can help you sway power within these structures itself. That is not to say that they will do it without you. And they were saying, look, you can tell us this, but at the same time, you need to be mobilizing outside. You need to be knocking on our doors constantly and telling us, why haven't you done this? We need to see what's happening. And so we can't have a single-minded approach. And at the same, on the other hand, we've also worked within government structures with a tactical alliance, albeit tough at times, with the EFF, where we are now, a bill has been gazetted, which would strengthen the legislation of SARS and other tax authorities to ensure that they can legislate and litigate on issues where there is fraud, corruption, particularly around illicit financial flows, base erosion and profit shifting. So I think it's about seeing where and how you can use these different levers to push this work forward in creative and imaginative ways. In terms of litigating, 100%. I have a reputation for having a foul mouth, but I will say we need to put these people who are behind these things through the beneficial ownership registries, seeing who are the ones who are really gaining from this, including the auditors and the lawyers, who, by the way, will come to that. We need to be able to put these people behind bars, because I think this is a major statement. And in fact, we are going to be doing this, where we're going to be taking up a case against a major multinational corporation in South Africa, and watch this space. We can speak to you, some of you about it, but very privately, because it's got major repercussions. But litigating it's key. We have to use that as another front of struggling on IFFs and PEPs. This is a question, and it's also a comment, and it's my wrapping up point. And that is that I agree that we need to break up the power of the auditing firms, as well as the lawyers, exactly. But now, just a quick mark on the big four. They are definitely being incentivized. 2 years ago, the gross revenue between the four of them was $130 billion. I mean, that's a huge amount of money that is being paid for people to be able to avoid paying taxes. So my question is this. Yes, we agree. Let's break them up and also do the things that you were talking about, the ABCDs that was mentioned, etc., using these things. But how do we break up these auditing firms? What are the concrete ways in which we can do it? And I'm hoping someone will come to me over tea and tell me this and this is how, so we can take that further. Thanks.
Par rapport aux deux questions qui m'ont été posées par monsieur, d'abord par rapport aux actions à entamer contre les Big Four, vous avez parlé notamment de la sensibilisation. Je pense que s'il s'agit de la sensibilisation, elle a déjà été faite. Nous avons vu la publication des Panama Papers, des Paradise Papers, Swiss Leaks, West African Leaks. Donc, au niveau, on peut dire que les médias ont fait quand même leur part du boulot. Donc maintenant, la question, c'est une question de volonté politique. Nous savons tous que l'ennemi principal des Big Four, c'est la transparence. Notamment la transparence au niveau des noms des bénéficiaires, la transparence au niveau de la publication des comptes, également au niveau de la coopération entre les pays. Nous avons vu par exemple qu'une tentative d'évasion fiscale au niveau de la douane peut être évitée à partir de l'utilisation des données miroirs. Les données miroirs, il s'agit de comparer les données, par exemple, qu'une entreprise a déclarées au Madagascar et au Kenya, la même entreprise. En comparant ces deux données, on peut voir s'il y a des gaps entre ces données. Donc tout cela révèle de la coopération entre les États. Il faudrait aussi essayer de ramener ces entreprises vers les règles comptables de base, les règles comptables des Nations Unies, et non ces règles comptables qu'elle s'évertue à appliquer depuis les années 1970. Il s'agit simplement d'appliquer les principes comptables de base, notamment le principe de sincérité, également le fait que la comptabilité doit présenter une image fidèle des activités de l'entreprise. Par rapport à votre deuxième question, les Big Four en eux-mêmes, je ne suis pas sûre qu'ils aient été traduits devant la justice, ces acteurs, mais ce dont je suis sûre, c'est qu'il y a beaucoup de leurs clients qui ont eu des problèmes d'évasion fiscale qui ont été avérés et qui ont été traduits perdues devant la justice, qui sont amenées à payer des pénalités d'impôts. Comme je l'ai dit lors de ma présentation, une solution peut-être, ce serait de faire contribuer les Big Four au remboursement de ces sommes d'argent au niveau des impôts. Donc je pense que c'est tout ce que j'avais à dire par rapport à cela. Je vous remercie.
Look, I know Kanye is... Oh, sorry. We're still in public. I know Dr. Shabalala. I'd forgotten two important things, that I'm a male and we're in public. I was going into a private address. My friends, this conversation about lawyers and accountants is a difficult one. We left out of this the priests. One of the biggest industries for illicit financial flows on the continent is religion. Speaking about religion, there are two interesting short stories as we close. Is that three priests, one Catholic, another one Anglican, and another one from another sect of the Christian faith, met to determine how they coped with issues of personal political economy. So the Catholic man says, well, every once in a year at Christmas, I ask the parishioners to give something. You know, as a Jesuit, we vowed a vow of poverty. So they bring stuff and we distribute to the orphans and the widows. And we keep a small amount that we use just to replenish the parish. And the Anglican chap says, well, we're not different. We take 3 times a year. And we use this money because, as you know, we run institutions. And so we give also to charity and ensure that, you know, we then keep a little that pays salaries for church workers and so on and so forth. And the other chap said, are you okay? I said, why? I said, this issue of money is between you and God. What I do is every day I take tithe and offering. And I put it all in a big basket. And I pray the following prayer. Dear God, I have received gifts from your people. I'm going to throw them up. Whatever you want, you keep up. What comes down is mine. Second one was similar. You know, exorcism of demons. So a chap came to church with a demon and they were trying to cast the demon out. And I'm told the demon speak. So the demon started, so the pastor said, I'll cast you out. And said the demon was a bit rude. And then the pastor said, hey, demon, what are you doing in this man? The man was a lawyer. And the demon said, I want him to win $60 billion lotto today. And then the pastor dragged the demon to the side and said, come out of that man, come here. You know. And you heard that these lawyers are always talking about honesty and integrity. There is one contradiction that's on any grave. Here lies a lawyer and an honest man. So that means there will be 2 people in that grave. It's not possible to... so I was saying to you that what happened is that there is a man who had a banker, an accountant, and a lawyer. He was a very wealthy client. We're going back to your ethics story. And then said to them, I have been diagnosed with cancer, and the doctors have told me that I have less than 8 weeks to live. As you know, I'm a man of great means. And what I wish to do is to break down my estate into 3 equal installments. But there is a catch to this. On the day that I die, I want you to bring all my wealth, which I'll have divided into 3 equitable installments between the lawyer, the banker, and the accountant. Please, can it be put in my grave or interred with me? So as it happened, there was a priest also there. As it happened, they came and everybody seemed to be throwing something in this very big grave. The car was thrown in there and many things. The house was sold. They pretend to be throwing. So they then sat afterwards reminiscing about this great person. And the priest says, the lawyer says, I want to know if your professions are accountable, if you are transparent, if you are ethical. Mr. Priest, did you do it? And the priest says, oh, I threw in everything, but as you know, he liked the work for widows. So I kept a small amount for widows. And the lawyer said, shame on you. You could not honor the word of a dying man. Then he went to the banker. The banker said, well, I threw in everything. I just withheld bank interest because the interest was due. He said, oh, shame on you. For all the money he paid you, you couldn't pay the interest? Then they went to the, so they had the banker, the accountant. The accountant said, I threw in everything. Except, you know, there was one final account for the estate. And the lawyer was outraged. I cannot believe that your professions do not know how to uphold basic ethical standards. So everyone turned to the lawyer and said, and you, did you throw in everything? He says, yes, I threw in everything by check. So he wrote a check and threw it in there. That means he kept. I'm telling you this story in order to say to you, two things will happen from henceforth. The first is that we are going to have a launch at 6:30 to 8 p.m. by Oxfam of a policy brief on domestic resource mobilization. It's going to be in Babalu's room, which is near the reception. If you just, it's Babalu's. It's up from the reception on the mezzanine floor. You are all invited. There's no charge for the launch. The only request we make is that should you take any drink that somehow alters your please make sure you wake up early tomorrow because we're starting on time at 9. And at 9, when you come in tomorrow, the rooms will have been split into 2. Into actually 3. We have parallel sessions starting tomorrow. And let me walk through what those 3 sessions are. If you look on your programs, we are now looking at the socio-economic or the human dimensions of IFF. And that will do from 9 to 10:30 so that we're not constantly extending time. If you are here by 8:30, 8:45, we'll start on time. There will be the human cost of corruption in the fight against IFFs from Africa, looking at the human rights approach to IFF, right? All the rooms will be labeled, and there will be people to show you where to go. Then the second will look at, so we've looked at the cross-boundary facilitation of IFFs through corruption. And then we will have the role of the media and parliamentarians in fighting corruption. Just to rehash those, the role of the media and parliamentarians in fighting corruption, cross-boundary facilitation of IFFs through corruption, and then a human rights-based approach to IFFs from Africa, which is looking at the human costs. My suggestion is make up your mind tonight which of the sessions you will join. I would like to thank you and your session. You were very lively. I didn't see anyone sleeping. The only gentleman who seemed to have their eyes closed was deeply reflecting on the content of the discussion. They were not sleeping at all. Allow me to thank you and to thank the eminent panel of broad lawyers, accountants, and activists. Thank you so much for your incisive comment. May you have a restful evening. Please, someone buy them a free drink at the Oxfam cocktail. They deserve it. A pam-pam for them. Please, I'd like to remind you